Welcome to the Deep Dive.
Thanks for having me.
Today we are going to be looking at Helsinn Healthcare S v. Teva Pharmaceuticals.
Yeah.
So this is a patent law case.
It is.
And basically what happened was Helsinn had this patent.
Right.
And they sold it before they filed the patent.
Right.
And the question before the court was whether that sale counted as putting the invention on sale.
Right.
So that's like the most basic.
Yeah, that is the crux of the issue.
Yeah.
In patent law, there's this thing called the on-sale bar.
Right.
Which basically says that if you offer an invention for sale more than a year before you file a patent application,
Yeah.
you can't get a patent.
Right.
So the idea is to prevent inventors from commercially exploiting their inventions for too long without seeking patent protection.
Okay.
So the question in this case was whether this sale to a third party under a confidential agreement before that 1-year deadline triggered the on-sale bar.
Okay.
So this is where the AIA comes in.
Right.
This is the America Invents Act, which was passed in 2011.
Okay.
And one of the things the AIA did was amend the definition of prior art to include the phrase or otherwise available to the public.
Right.
So prior art is basically any information that's out there about an invention that could potentially prevent it from being patented.
Right.
And so the addition of this phrase, or otherwise available to the public, created a lot of debate about the scope of the on-sale bar.
So how did the two sides in this case kind of break down on this issue?
Well, Helsinn argued that the on-sale bar only applies to inventions that are publicly available.
Okay.
They said that the AIA's addition of or otherwise available to the public actually clarified that public availability was a requirement.
Okay.
So they argued that because their sale was confidential, it wasn't publicly available. And so it didn't trigger the on-sale bar.
Okay.
Teva, on the other hand, argued that any commercial offer for sale, even a confidential one, triggers the on-sale bar.
Okay.
And they said that the AIA did not change.
Yeah.
That's the long-standing interpretation.
Okay.
And they relied heavily on a 1998 Supreme Court case called Pfaff v. Wells Electronics, which said that a sale is a sale, even if it's confidential.
So it sounds like there's two very clear sides to this issue.
Very much so.
So how did the actual oral arguments go?
Well, it was lively.
Okay.
The justices had a lot of questions for both sides.
Okay.
Chief Justice Roberts, for example, questioned whether Helsinn's interpretation of on sale aligned with the common meaning of the word sale.
Interesting.
Like if I sell you something.
Right.
Doesn't matter if it's a secret.
Right.
Justice Kavanaugh expressed skepticism that the AIA was merely meant to clarify the on-sale bar, especially since Congress had failed in the past to explicitly change the law in this area. Justice Breyer really dug into the historical precedents, citing cases going all the way back to Justice Story in the 19th century.
Wow.
And he seemed to suggest that the purpose of the on-sale bar was to prevent inventors from profiting from their inventions, even in secret, before getting a patent.
That's interesting.
Justice Ginsburg wanted to know if Helsinn was arguing that the AIA didn't change the on-sale bar at all.
Right.
Justice Sotomayor asked the government who was supporting Helsinn in this case to define on-sale to the public. And she also asked about how international patent systems treat private sales. Justice Kagan explored the meaning of the word otherwise in the AIA through a series of hypotheticals. Justice Alito raised concerns about the plain meaning of the statute. And Justice Gorsuch asked about whether the court should give any deference to the Patent Office's interpretation of the law.
So it sounds like the justices were really trying to grapple with all the different angles of this issue.
Absolutely.
And what about the legislative history of the AIA?
Well, both sides tried to use the legislative history to support their arguments. Helsinn argued that Congress clearly intended to codify a public availability requirement for the on-sale bar when they added that or otherwise available to the public language. But Teva countered by pointing out that Congress had previously considered and rejected proposals to explicitly change the on-sale bar to require public availability.
So they were saying that if Congress really wanted to change it, they would have just done it explicitly.
Exactly. And so they argued that the AIA should not be interpreted as implicitly changing the law.
Okay, so beyond just the sort of nitty-gritty legal arguments, what were some of the bigger policy considerations that were at stake in this case?
Well, one of the big issues is the balance between encouraging innovation and promoting public access to new technologies. So the on-sale bar is meant to prevent inventors from extending their monopoly by commercially exploiting their inventions in secret for a long time before filing for a patent. But if the on-sale bar is interpreted too broadly, it could make it difficult for companies to raise money and develop new products because they might be afraid to even talk about their inventions with potential investors or partners.
Okay, that makes sense.
Another policy concern was whether a confidential sale really harms the public. Helsinn argued that as long as the invention is kept secret, the public doesn't lose anything. But Teva argued that even confidential sales can have a negative impact on innovation.
How so?
Well, they said that it could discourage other inventors from working on similar inventions. Because they might not know that someone else is already ahead of them. And so they might give up too soon.
Interesting.
Or they might not even start working on it. Because they think that the field is already taken.
That's really interesting. So ultimately, it sounds like this case really hinged on how to interpret this phrase on sale.
That's right.
So for the 10th chair segment, I would love to get your take.
Sure.
So how do you think this case should have been decided?
As the 10th justice, talk testimonies would likely have voted to uphold the Federal Circuit's decision in favor of Teva. And this is mainly because of that long history of interpreting on sale to include commercial offers. Even if they're made confidentially. The on-sale bar has consistently been about preventing inventors from delaying their patent applications. While they are already commercially benefiting from their invention. And a confidential sale still shows a clear intent to profit from the invention.
So even though the AIA broadened the definition of prior art, you don't think it changed the fundamental meaning of on sale?
That's right. If Congress wanted to require public availability, they could have explicitly said so. And they didn't. So we think that maintaining a clear and consistent rule is important for encouraging innovation. And for ensuring that inventors seek patent protection. In a timely manner. And this also ensures that the public benefits from new technologies.
That makes sense.
Sooner rather than later. And just to be clear, our 10th chair analysis is just our opinion. It's not a prediction or legal advice.
Of course.
The actual decision involved many complex considerations. And we encourage you to learn more about it.
This was such a great discussion.
Thank you.
I think that really clarified a lot of the issues at stake in this really fascinating case.
I agree.
So for our listeners, we'd love to hear your thoughts. Do you think the Supreme Court got it right? Or wrong? Join the conversation. And share your thoughts on our website. And thanks for listening to The Deep Dive.
My pleasure.